In April 2011, police arrested four men in connection with a series of armed robberies. One of these men confessed and provided the FBI with his and other men's cell phone numbers. The FBI used this information to apply for orders from magistrate judges to obtain transactional records for each phone number.
The judges provided FBI with these records under the Stored Communications Act of the United States Constitution, which states that the government may require disclosure of certain telecommunication records when specific and articulate facts show that there is reason to believe that the contents of a wire or electronic communication are relevant to an ongoing criminal investigation. Transaction records obtained by the FBI in this instance included dates and times of calls, as well as the approximate location where calls began and ended based on their connection to cell phone towers.
The man who pleaded guilty, Timothy Carpenter, was charged with aiding and abetting or assisting the robbery, which affected interstate commerce. This is in accordance with the Hobbs Act. However, Carpenter decided to refute the government's use of his cell phone records as evidence using the Fourth Amendment. He argued that the FBI should have a warrant in order to obtain this information.
This case ultimately made its way to the Supreme Court, or SCOTUS. The ultimate question that Carpenter versus the United States boils down to is whether the warrantless search and seizure of cell phone records violates the Fourth Amendment.
The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation. This means amendment protects U.S. citizens from unreasonable searches and seizures by the government. This emphasizes that authorities typically need a warrant based on probable cause.
What makes this case difficult is the presence of cell phones. In an evolving technological world, what information does the government have a right to? Should they have had a warrant in order to obtain Carpenter's cell site records? Let's hear from Carpenter's lawyer.
At issue in this case is the government's warrantless collection of 127 days of petitioner's cell site location information, revealing his locations, movements, and associations over a long period. As in Jones, the collection of this information is a search, as it disturbs people's long-standing practical expectation that their longer-term movements in public and private spaces will.
SCOTUS sided with Carpenter in this case by a 5-4 majority. They ruled that law enforcement needed a warrant to access cell site information that would map a criminal suspect location based on their phone's interaction with cell towers. Therefore, the warrantless acquisition of Carpenter's cell site records was a violation of the Fourth Amendment.
The slim majority asserted that tracking movements and location through extensive cell site records violated Carpenter's reasonable expectations of privacy under the Fourth Amendment. The dissenting 4 justices argued that the cell phone records were not the property of Carpenter, but rather his cell phone company.
This case is extremely difficult, as both sides have a well-founded argument based on the Fourth Amendment. One deciding factor was the way in which cell phone data was collected. Due to a certain data retention policy that Carpenter's cell service provider had, Carpenter had no say in what information was provided to the FBI. This further contributed to the argument that the warrantless acquisition of cell site records violated Carpenter's reasonable expectations of privacy under the Fourth Amendment.
Carpenter v. United States is a complex case that demonstrates the issues of applying the Constitution in an evolving digital world. This case has helped to set the precedent for what data the government has a right to, and what data they don't. As for you, do you think SCOTUS made the right decision? Carpenter v. United